Okay. The following classes of persons subject to military law shall be placed in arrest and confinement as follows. First is enlisted person. By officers only in person, through other persons subject to military law, or by oral written orders or communication. Next, officers, probationary lieutenants, and cadets. By commanding officers, only a person through other officers or by oral and written orders or communication. The authority to place such persons under arrest confinement can be not be delegate. Okay, those are the following persons subjected to military law. Where any person subject to military law is placed under arrest or confinement, immediate steps are taken. Either it prefer charges against him with the view to bring him into a trial and carry the case of the final conclusion, or dismiss the charge of subsequently release him, by who are initiate to prefer the charges against the erring military man. They are as follows. So anybody, first we have the anybody, or whether subjected to military law or into any give information to military authorities concerned that an offense is supposedly committed by the person subject to military law. Okay. So, natay gitawag og SJA, Staff Judge Advocate. Mao ni ang mga tawo nga mo-conduct og investigation like abogado or mga CI, mga civilian intelligence, pwede pog military intelligence. Muna sila ang mga committed by the person subject to military law. So, next, any person subject to military law may prefer charges against a military offender although he is under arrest or confinement. In minor cases, however, the necessary information is brought to the attention of the immediate commanding officers of the accused, where no formal investigation is conducted. The charges are referred to an investigating officer. This officer conduct the investigation to determine whether a prima facie case exists. Prima facie. The reports of investigation is submitted to the Staff Judge Advocate, or SJA, for his study and advice. Okay. If it is determined that no prima facie case exists to warrant trial by court-martial, the case either dropped or some other appropriate action is taken. On the other hand, where the Staff Judge Advocate determines that there is a prima facie case, he recommends to the commanding officers exercising court-martial jurisdiction to referral of the case to the court-martial for prosecution. The action of the commanding officers on a case disposable by operation of the Article of War 105 shall be discussed under the separate subtopic of this chapter. So, the commanding officers appoints a court-martial to try the case. Once the trial is terminated, the results of the conviction of the accused, the sentence as adjust as ordered, promulgate until it is fully served. If, on the other hand, the trial ends in the acquittal of the accused, he is immediately ordered release from confinement and restored to military duty. So, mauto siya. Let us now proceed to the rule of court-martial and the other tribunals. Court-martial and the other military tribunals generally exist to assess commanders in the administration of military justice. Specifically, they are established to enforce discipline in the military establishment and to serve as deterrents to military crimes and offense, and by every nature of the conduct of trial. This court-martial and the other military tribunals hasten the administration of military justice. Okay, let us look into the jurisdiction of the person, offense, and punishments of each of the three types of court-martial and substantiate the Constitution just cited. A special court-martial, on one hand, has the executive jurisdiction to try all other persons subject to military law, excepting officers for offense not capital in nature and whose probable sentence include confinement not exceeding 60 months, restriction to limit hard labor without confinement not exceeding 3 months, and reprimand, admonition, and demotion in ranks. The proceedings conducted are not as tedious as those for a general court-martial. An entirely different case would be the trial by the summary court-martial, where its proceedings are much faster than those of the other types of court-martial, since it has at least one member who sits as president, trial judge advocate or TJA, and defense counsel. At the same time, and since its jurisdiction as to person, offense, and punishment is limited, summary court-martial can dispose of a certain case in most predictions manner. A summary court-martial can try private first class and NCOs below training sergeant for offenses not capital in nature. It can judge judgment as follows: confinement from 1 month, restrictions to limit for 3 months, and for features or detention of 2/3 pay of 1 month. Okay, in military commissions or tribunals play the same role as a court-martial during the martial law, which was in effect throughout the country from 1972 to 1981. This commission or tribunals tried cases referred to them in the same expeditious way. Even civilians who committed offense not subject for trial by the court-martial fell under the jurisdiction of the special bodies whose proceedings were in accordance of the procedural law mentioned. Must be made here that the Chinese national who was accused of drug punishing and distribution was found guilty by the military commissions and out the death penalty through musketry. These bodies had helped in the faster dispensation of justice, which would have taken years to dispose of under normal conditions. So, in the military commission or tribunals to siya. In punitive articles of war, as gleaned from historical records, the articles of war were promulgated effective September 14, 1938. September 14, 1938 when the unicameral Philippine National Assembly punitive articles of war. As gleaned from historical records, the articles of war were promulgated effective September 14, 1938, when the unicameral Philippine National Assembly enacted Commonwealth Act number 408, which became the basic law that gave the guidance in the operations of the country's armed forces, then known as the Army of the Philippines. Then as now, there are 120 articles, most of which were lifted from the U.S. Uniform Code of Military Justice. It is for this reason that our articles of war had the same substance as the American Military Code of 1928, which was found applicable of Philippine conditions. Of the 120 articles of war, 52 are considered as the punitive because they specify that punishment is to be imposed for each military offense committed. Articles of war 54 to 105 inclusive are the punitive articles. These are two broad categories of crimes or offenses included the punitive rules in articles of wars, and these are the crimes or offenses that are similarly within in the contemplations of the revised Penal Code of the Philippines, and then the offenses that are strictly classified as purely military. Article of War 105. This particular article of war empowers commanding officers of units to punish personnel under them or minor offenses without the intervention of the court-martial. This is the most expeditious way of disposing minor cases without necessarily sacrificing the ends of justice and military discipline. Okay. Under the Article of War 105, commanding officers are authorized to impose the following penalties under their broad disciplinary powers. First, we have admonition. So when we say admonition, it is a criticism or warning about behavior. Admonition. So, mo na siya. Na ay mga warning sa behavior as an individual. So, next is reprimand. A server or formal to speak in an angry and critical way to someone who has done something wrong, disobeyed an order. Okay, next is suspension of privilege for a period not exceeding 1 week. And then, the fourth one is extra fatigue not exceeding 1 week. So, when we say fatigue, it is the state of being very tired, extreme weariness, or the, in the other words, pwede mo siya katong the uniform that soldiers wear when they are doing physical work. Next is hard labor without confinement not exceeding 1 week for privates and private first class. Or the confinement or an act of confining someone, the state of being confined. Then the last one, under Article of War 101-105, any combination of the penalties just cited not exceeding 1 week. Okay, so, mao to siya. Those are the 6 commanding officers are authorized to impose the penalties and under their broad disciplinary powers. So, these authorized punishments may be imposed only when the offenders not demand trials by a court-martial. So, this is a basic requirements to be met before any form of punishment can be imposed. So, dili na sila basta-basta mag-punish. Naadyo na sila i-follow nga rules. So, once okay. So, once an accused demand trial by a court-martial, the necessary charges are preferred for trial by the court-martial vested with competent jurisdiction. So, Okay, cadets, that is all about in military justice. So, lesson that we tackle. All you have to do is to kanang mag-active ra permi sa ato messenger group chat. The 4th Platoon Bravo Company. Good luck, everyone.